We now call 22-39417, the state of Texas versus Jacoby Damon Broussard. You, Mr. Broussard, present with your attorney, Mr. Adams, and the state's attorney.
Yes, sir.
Earlier, you entered a plea of guilty to the first-degree felony of murder in this case.
Right here is where everything becomes real. A first-degree felony murder plea means this isn't about guilt anymore. It's about how many years of this man's life are about to disappear. The judge isn't deciding if he's responsible, only how hard the law is going to hit him. And trust me, that difference matters.
A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? State?
I've reviewed it. I have no objections or changes, Judge.
And defense? Then without objection, it's made a part of the record for all purposes here. The agreement is whatever sentence shall not exceed a cap of 30 years imprisonment. So we really are looking at no less.
This is a massive moment. The sentencing range is locked in, 5 to 30 years. No parole tricks, no alternate punishment. Every argument from this point forward is a tug-of-war over decades. So the question becomes, who really deserves the harshest punishment in this case?
Less than 5 no more than 30 years confined in prison. I believe there aren't any other options, correct?
Correct.
Is that the way you understand it, Langston?
Yes, sir.
All right. State, want to go first and last?
I'd like to go last, Judge.
You can go first and last. You can defer. Mr. Adams, go ahead on behalf of Mr. Broussard.
Judge, if you look at page 1 of the pre-sentence investigative report, and I'm looking right above defendant's version, you'll see that it was 3 people that was all charged with murder: Jacoby Broussard, Arthur Small, Charles Moss, and they all were charged with murder. Prior to today, it's my understanding that Arthur Small and Charles Moss has already pled before your court, Judge. And Mr. Helm can correct me if I'm wrong, but I understand that Mr. Small got 8 years, and at that time, Mr. Small was already on probation in your court for another case. And then I believe Mr. Moss, and Mr. Helm can correct me if I'm wrong, I understand he ended up pleading for, I believe, 15 years, 20 years, 15 years, I believe. So what I'm asking, Judge, is if you...
Now, defense strategy comes into focus. They're not denying tragedy. They're arguing comparative blame. Same crime, different sentences. And in sentencing court, judges do care about fairness. But here's the risk. When you start pointing fingers, you also risk looking like you're dodging responsibility.
Look, and I'm only looking at page 1. When you look on page 1, Judge, you see specifically where Mr. Thomas was shot at the canal, and then he apparently had got into a fist fight, and I'm reading specifically where it says when he witnessed the fight between Thomas and Trey Moss. Trey Moss was the one who was already in your court, and I believe he took a 15-year deal. He is the one that got into the physical fight with the deceased in this case. And then apparently the deceased came back and there was gunshots. Judge, the thing that we would add to the PSI, and Mr. Helm has already provided this to my office, was the forensic post-mortem examination. And I do not believe Mr. Helm is going to contest that according to Judge, what I was going to tell you is according to the forensic exam, the deceased had a gunshot wound through the right thigh. So he took a bullet to the right thigh, and also it says it was another bullet to the left side of his abdomen. And that's in this report, Judge. Here you go, Judge. I'm just showing that he was shot twice. One to the thigh and then one to his abdomen. Okay. So our position after this. Yeah. So our position, I can make a copy. You have got it. Oh. So what I'm saying, Judge, is that there were 2 shooters, and we believe that to make in line with what my client said where he said in the defendant's version of what happened.
How many times was the complainant, the victim, shot?
Well, we know he was shot twice because he was,
At least.
because one was to the thigh, and that's what I'm looking at right there, and the other one was to the abdomen. So we believe that there was 2 shooters, and with the 2 shooters, and that's revealed, and there was 2 wounds. And I was letting you see where I got that from. It's our position that the wound to the abdomen came from Mr. Moss, and then apparently the wound to the thigh would have been my client, Mr. Broussard. And Judge, if you look specifically, and I'm ready.
Why do you say that?
This is where the courtroom tension spikes. The defense suggests 2 shooters based on autopsy wounds, but notice what's missing? Ballistics, forensics, proof. In sentencing, speculation can backfire fast, especially when a judge starts asking, how do you know that?
Well, how can you determine that not being present?
No.
And not having any other scientific evidence to support that other than
Because he was there.
okay, it's what he's telling you.
Right, because he was there, because he saw everything. He would have been there. And Judge, what I'm saying
So what is it you're saying his responsibility was? What did he do?
what I'm saying with there being with the victim being shot twice, I think, hey, he's a party to the offense. But what I was asking, Judge, is that when you look specifically to his criminal history, unlike Arthur Small was on probation when this happened, and he agreed to be a witness for the state to testify against my client. And then unlike Mr. Moss, who's the one that's actually having a physical confrontation with us, it wasn't my client. And I'm asking, if you just read from the PSI, the guy who's the instigator of all of this is Mr. Moss. He's the one that's beating up the man and having a physical fight with him, and he's the one that has more incentive to shoot him than anybody because he got to fight. And our position is that you had 2 shooters, and that and having 2 shooters, my client is culpable for firing the shot, but the one who is the most culpable is Mr. Moss. And again, like I said, Mr. Ham can correct me, but I thought, if I'm not mistaken, he received 15 years. I could be wrong, it might be 20, but I know it was not 30 years. And what I'm asking the court is, Judge, is that if the man who we believe is the most culpable got 15, or I know it was no more than 20, then I don't believe my client should get the max out 30 years. And the reason I'm concerned about that is that, Judge, if you look on page 2, I see where the mother in there said that she wanted him to get 40 to 50 years in prison, and the dad felt that he should get more than 30. But in my opinion, Judge, in arguing on behalf of my client, the person that was most culpable was Mr. Moss. And Mr. Moss did not get a 30-year sentence. And since he didn't get a 30-year sentence, it's not going to be fair for my client to get hit with 30 years when the man who was most culpable was not. And that's why I showed you, Judge, that it was at least 2. There's no doubt, according to the autopsy report, it's no doubt he was hit twice. And absolutely no doubt about that. One to the thigh and one to the abdomen. And I think that my guy is responsible for the thigh, but he's not responsible for the one that went to the abdomen.
You've seen the pre-sentence report.
Yes,
He's not responsible for it.
No, I didn't say that.
That's what he says.
Okay, but
He's not. He didn't shoot anybody.
no, I hear you. And I
So,
think that,
but you're saying he did shoot somebody.
I think he needs
Is that
to
right?
clarify that. Yeah, he needs to clarify that.
Oh, he does.
Right.
Well, he was pretty clear here in that he pleaded guilty, which was odd, but then he later admits he didn't shoot anybody. That's his inference here. But you're saying he did, even though you weren't there.
I wasn't that, Judge, but the thing is, like I said, and the reason why I brought that to your attention, just looking at the autopsy report, to suggest that there was 2 wounds, and there's no doubt about that.
I'm not surprised. I'm looking at what all this says. It
Yes, sir.
appears as though 2 people did shoot. That's why 2 people apparently pleaded guilty.
Right, and it's actually 3
But-
people charged.
But in the pre-sentence report, he's trying to play both sides. I'm guilty, but I'm really not. He can't figure out which one he gives, Dr. Jekyll or Mr. Hyde.
And
That's kind of a problem.
That's why I was trying to reconcile his statements with the objective
How do
data.
you reconcile he didn't shoot anybody who's pleading guilty, wants to accept responsibility? How does that work? How does it work?
No, I think that he's
And here's the judge's real problem. You can't plead guilty under oath and then walk it back later. Courts expect consistency. To a judge, this sounds like someone trying to play both sides, accepting the deal but rejecting the blame. And that's a dangerous position when your freedom is on the line.
accept responsibility for firing.
But that's not what he says here. When he had a chance, he pleaded guilty under oath, but when he went to talk with the probation officer, he changed direction on wait. Being truthful and forthcoming is important. Do you know what happened here? A human being died. A human being, one of God's creatures. You had responsibility with that as well as the other person. Look, you killed somebody. You feel anything bad about that?
Yes, sir, I do.
Well, do you? You
Yes, sir.
certainly weren't forthright here at the probation office. You want to just interrupt me?
No, sir.
That's the way you are, isn't it?
No, sir.
I get the feeling you like to control the situation, like you control this shoot. You seem to be the boss.
No, sir.
No, that's the way it looks.
No, sir, you're the boss.
Well, no, that's the way, and that's not the way this pre-sentence report appears. You want to play both sides. I want to make a deal, but I didn't do it. Can't have it both.
No, sir.
I'm gonna let you talk for just a second. I want what Dave have to say.
You ready, Judge?
Yeah, go ahead.
Let me address some of the statements by defense counsel so that we can get on the right page. Mr. Small pled to a lesser included offense of manslaughter and received 8 years TDC. That was all part and parcel of an agreement for him to testify against Mr. Broussard. He stated at the time of this incident and reaffirmed during.
You feel, by the way, you feel like that is fair and appropriate under the circumstances.
Yes, sir.
Go ahead.
He's stated early on and then reaffirmed during trial preparation that Jacoby Broussard is the only person that shot Christopher Thomas on that date. There was a fourth person that was there. All this is a part of discovery. That individual's name was Ladarius, and he's Ladarius Lofton, and he's been cooperating since the incident occurred. He was one of the 4 individuals in the car, and thanks to him, he came forward whenever this body was found and told the Port Arthur Police Department about the fact that this young man was actually killed. Up until that time, they had not seen the bullet wounds in the body. The body was found in the ditch, but they mistakenly believed that it was some kind of an overdose. Had Mr. Lofton not stepped forward, we never would have gotten to the point where a murder investigation would have proceeded. He was not charged.
This statement from the prosecution flips the entire defense narrative. A cooperating witness, a body nearly written off as an overdose, and one shooter identified. If the judge believes this version, then the argument about shared blame collapses completely. So ask yourself, should cooperation reduce punishment, or does pulling the trigger outweigh everything else?